Hello friends, in the series on income tax cases, today we will discuss a very important case on the penalty under section 271 subsection 1 clause C, where the assessing officer imposed the penalty for concealment of income, where the assessee has not shown the capital gain into his return of income and he has offered that income only after the issue of notice to him. In the present case, the main issue before the Pune ITAT was that in income tax matters which are civil proceedings, whether the revenue has to prove the mensrea on the part of the assessee before imposing the penalty on the assessee. These both issues have been decided by Pune ITAT in the case of Kishore Madhav Paranjep versus Deputy Commissioner of Income Tax, and this case is reported in 97 ITR Tribunal, short note 45, and the date of the judgment is 30th June 2022. In the present case, the assessee is a partner in various firms engaged in business of land development and building construction. The assessee has not shown the capital gain on the sale of land. The notice was issued to the assessee. The assessee offered the capital gain on the sale of the land, and the assessee did not prefer the appeal for the quantum additions. After that, the assessing officer issued the show cause notice to the assessee for imposing the penalty for concealment of income. The assessee said that since the assessee has suo motu offered the income to tax was not accepted by the income tax officer and the penalty was imposed. When the matter came before the CIT appeal, the CIT appeal also upheld the penalty order, and so the assessee filed the appeal before the tribunal, and first time before the tribunal the assessee produced some letter from the land revenue authorities which was showing that land was 9 km away from the municipality. The tribunal said that in that letter the manner of calculating the distance has not been mentioned, and since the assessee has not given these documents before the lower authorities, so this matter should be remanded back for the fresh consideration. At the same time, the tribunal said that the assessee plea that this matter is time barred is not justified because section 275 subsection 1 clause C is not applicable because no appeal has been filed by the assessee. The tribunal said that in the present case, the assessment order has been passed in the month of December 2017, so the penalty order passed in the month of June 2018 is not time barred. The tribunal said that the penalty order is to be passed within 6 months from the end of the month in which the assessment order is passed, or in the at the end of the financial year in which the assessment order is passed, whichever is later. So in the present case, the penalty order is not time barred. The tribunal said that in the present case, the assessee pleaded that he was not aware of the distance is far-fetched because the assessee is a regular investor in land and this plea cannot be accepted. The tribunal said that because the income tax proceedings are the civil proceedings, and in civil proceedings there is no need to prove the mensrea on the part of the assessee, so the assessee plea that the mensrea has not been proved is also not will come in the rescue of the assessee. Friends, this case is very important because in the present case, from the facts of the case, the intention of the assessee can be determined because the assessee was a regular investor in land, so he must have been very much aware that whether this land come into the definition of agriculture or not. When the notice was issued, then he came to the notice that some income has escaped assessment, so he then offered the income. So in these type of cases, if the assessee would have been really honest, in that case the assessee should have challenged even the assessment order, and if at a very later stage, that is the stage where the proceedings are before the tribunal, if the assessee comes some additional evidence, so in that case the tribunal was very kind to the assessee in remanding the matter back to the assessing officer because no such document was produced before the lower authorities. So just because the assessee has offered the income to tax cannot escape the assessee from the penalty proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Kishore Madhav Paranjep versus Deputy Commissioner of Income Tax, and this case is reported in 97 ITR Tribunal, short notes 45, and the date of the judgment is 30th June 2022. Thank you, friends.